Hi guys, and welcome to Sessions with an Adoption Attorney. My name is Anthony Zarica. This is episode 6 of Sessions. We have our first guest on the podcast today, James Cortopassi. James is the owner of Litigation, and I'll let him speak on that company. Just to give you a little bit of background on James, James brings 20 years of litigation support experience to his practice as a leader in e-discovery coordination and trial technology. Mr. Cortopassi has managed over 1,000 cases involving forensic collections, data processing, and hosted solutions, managed document review, ESI productions, trial technology services, and workflow innovation. Mr. Cortopassi is a member of the Association of Certified E-Discovery Specialists and the Electronic Discovery Reference Model Coalition. Litigation has won numerous awards from the New Jersey Law Journal, and without further ado, here's James to give us a little bit of background on his personal side and with his experience with litigation.
Thanks, Anthony. I really appreciate being part of this podcast. Hello, everyone. My name is James Cortopassi. I'm the founder and operator of Litigation. We are an intimate litigation support and consulting firm, essentially established several years ago after 20 years of experience working with attorney firms and corporate entities. I decided to open Litigation and really concentrate on a consultative e-discovery approach for my clients during their litigation. Most of our services are done during the discovery phase. For instance, we handle forensic collections of data. These days, obviously, everything is stowed electronically or mostly stowed electronically, so that data needs to be collected. We have forensic examiners that could assist you in identifying anything responsive to your litigation. We collect that data from various forms of media. We interview folks that stow or data stewards of that data and get a good understanding as to where data that is responsive to your case may reside. Once that data is ultimately collected, we're then able to assist the attorneys and their end clients with the processing of that data, culling it down, removing anything that might be privileged or not responsive to the case, ultimately hosting it, of course, because that data needs to be reviewed. And once it's reviewed, we're able to then produce the data in a format that is in accordance with any orders or stipulations for that case. Additionally, we support trial. During trial, we handle what we call the bells and the whistles of the presentation. Sometimes you'll see it on a movie or TV where the monitors or screens are before the jurors, attorneys, counsel tables, as well as the witness and the judge. Nowadays, for the flow of a trial and convenience, as opposed to lugging boxes and boxes of hard copy evidence into the courtroom, attorneys find it very convenient to be able to project the data electronically on a screen and even annotate or put emphasis on certain points that's permissible during that trial. So again, a lot of heavy work during the discovery phase with the processing and the collecting the data, ultimately producing the data. Review teams. We establish, assemble, and manage data document review teams. Some of my clients prefer to have their own internal folks review it. It really depends on the amount of data that they're dealing with. If it's a smaller amount or less volume, then perhaps we host it at Litigation and allow them access. Today, most access is done web-based, wherein anyone could access a review platform from any computer with internet connectivity and take it from there, determine which data is germane to the case, the claims, the defenses. The possibilities are endless when you go electronic.
Great. Well, all that sounds very interesting, and we're going to get into in a little bit more detail with these questions that we're going to have. So the flow of the cast today is going to be basically me asking James about 5 questions. We're going to get some answers. And again, if anyone out there, as usual, has any further questions, you could reach me on the web at www.nycadoptionlawyer.com, and I'll give you all of James' information as well. And also everything will be below this video, and in the podcast we'll give some shout outs at the end, and you guys can reach us, ask any questions from myself or James. But getting into it, just one question I had to begin was, how did you see the need for a company such as Litigation, and what made you ultimately dive in and say, this is something the market needs, and this is something that I know I could provide at an excellent with excellent quality to people that need it?
Sure. I started my career pretty young. I was a teenager working in law firms out in New Jersey, and it became apparent to me very quickly, and this was in the 90s, that electronically stored data was taking over, and it was quickly inundating the litigation or legal industry altogether. And as a young guy, a paralegal, a law clerk, I was often tasked with figuring out how data was going to come off this particular disk or thumb drive that was produced to the firm I worked for, or the shifts or changes with the federal courts in filing electronically. I was that guy, and back then it was a little, it was a big task for a young guy. But for that, I wouldn't be the professional I am today. I was really put in the mix of a real evolution with technology meeting the legal industry. After about 10 years working with firms and working with electronic data and the increase in the data that was within the legal industry, I went on to law school myself. During law school, I was out in Michigan State. I quickly realized that law schools, or at least my law school, and certainly colleagues and friends of mine that were in law school during that time, was missing that element of that practical approach to technology meeting legal. Although we had some adjunct classes or some classes that dealt with technology and presentations, it was certainly far removed from what was actually taking place in courts or in good discovery practice. And there were some sharp folks, some sharp attorneys out there that were, I don't want to say taking advantage, but certainly they had the edge over their adversaries and their end clients because of their knowledge of the way data resides and technology in general. So it quickly became my thing to adopt the technology in the industry, and ultimately look to a career path that had me supporting firms, consulting firms, as it pertains to ESI, electronically stored information. Right. Shortly after law school, I took a job as a managing director for a litigation support company, a large company, wherein I directed all forms of e-discovery and management with the clients, consulting with the clients, assistance with drafting data requests, for instance, supplemental interrogatories and the like. And after 6 years, I realized that I certainly wanted to do this for myself and on my own. Certainly I have a team working with me, but I wanted to concentrate on more of a niche, intimate dealing with my client. So we offer here at Litigation something very different than a menu of services. All of our services start with a meeting, a conversation, an understanding as it pertains to the case at bar. What phase of the litigation are we in? What's the exposure of the litigation? What kind of budget we have? These are all real-life elements, and you certainly can't provide value to your end client, that being the attorney firms, without understanding this case. Fortunately, having a legal background and the cognitive legal degree, I'm able to read a complaint, kind of get a quick gauge as to, okay, this case is about X, Y, and Z. And again, not offer up a menu of here are your choices, but more of suggestions and back those suggestions up with good reason. While we offer much technology here, there's often a case where I say, you need to print those documents out, look at them quick, and get them produced or get prepared for this deposition or whatever it might be. Right. So it's that practical approach that I felt that was necessary for the industry. It's again, I use the word intimate because that's exactly what I am. A client calls, whether it's a long client or the first time I talk to them, I'm immediately looking to sit down with them at no cost to that client and get an understanding of the case, because I'm not able to earn their business, or my firm's not able to earn the business of that end client unless I could speak with absolute confidence and back it up with a legal basis and or personal experiences with other entities that are similar situated.
Right.
And that's why I started litigation.
And I think that's a good segue for our second question, which is, who is your ideal market? And you mentioned the intimacy between, client and, and services. And I think that's important because, you could have the first year solo lawyer who, is just learning how to go to trial and do these things. Or you could have the big firm client that's been doing it for 20 years, and you have to gauge through your experience of, how you handle this person, how you walk their hands through what needs to be done and what doesn't need to be done. Because you may have one client, again, that knows nothing, he's hot off the presses and just graduated law school and really knows nothing. And you have to really teach him, the right way of doing things, which ultimately could lead you to have a client for life. And you also have to deal with the the big firms that are also in need of your services that may have a a cursory understanding or even more extensive understanding of what you're doing, and then you have to tailor each matter to its own. So just talk more about your ideal clientele.
Sure. You nailed it, Anthony. I mean, you get these young associates, they come in by nature. They have a technology understanding or a tech background because they partake in social media or email more often, but they're not as advanced, of course, as a seasoned attorney when it comes to legal. Wherein you have or in the alternative, you have a very seasoned legal mind that, and this isn't everyone, but it's certainly, based on my experience, more likely than not, the more seasoned folks, they have their mindset, they're in their ways, they're hard copy type of guys or gals, and some of them don't want to hear it at all when it comes to technology, and others they just don't have the experience with the technology. So I come to the table from different points of view, and I certainly want to understand who I'm meeting with or speaking with and what their abilities are or understanding is when it comes to both technology and mostly discovery practice. So ideally, I'd be dealing with attorneys from firms. So they're going to serve as the agents and the first line for their end clients. Most of the attorneys I deal with are from mid-sized firms, I'd say. However, it's not uncommon for me to get a call from a solo practitioner. Some are sharp when it comes to the technology and certainly up to speed, and they believe they know what they want, or we can speak or start the conversation from an extended point. And others have absolutely no idea, admittedly, as to where to even begin. And frankly, there's part of me wants to be a teacher, and I enjoy speaking to the folks that just put their arms up and say, "What do I do?" or "Where do I begin?" And that's where I love what I do, and this is why I started litigation, to ultimately bring up certain options or show or proffer the solutions that pertain to their case, and kind of explain things and the different avenues that they have during their litigation. It's not uncommon for me to hear from an entity, a corporate entity client. However, more often than not, I'm hearing from the attorneys that represent them. But in some cases, I deal directly with insurance companies, corporate entities, large or small businesses. Additionally, I deal with the government. Definitely take part in the bidding process, whether it's local or federal government sectors. I certainly work directly with them in the support during their litigation as well. So those three prongs, the attorney firms, the corporate entities, and the government, is really where I get my business from.
Great. Here's a question that's actually interesting to attorneys such as myself. So how much does a non-litigation attorney need to stay current with the issues that are dominating the litigation sector? For example, I'm an adoption attorney. I don't really litigate too many cases. A lot of my work is transactional, a lot of paperwork. So what do I need to know, or attorneys out there like me need to know about litigation?
That's a great question. Certainly, I support litigation. However, I recently wrote a blog on this issue, wherein ABA Rule 1.1, the first rule, talks about attorney competence. It doesn't distinguish or isolate a litigation attorney from a non-litigator or any other type of attorney. And it says attorneys need to be competent. And to be competent, you need to possess skill, knowledge, be thorough, and ultimately prepared for what a client might bring to the table. Mm-hmm. So even when you're drafting or when you're dealing with transactional work, you're going to need to know the parameters of technology, how it pertains to different businesses, how data is stowed, where it may reside, slack space or deletion of data, and what's accessible still. Or even more so, dealing with your own client's data. Certainly when you're drafting a document, a legal document, you're requesting or you're receiving information, sometimes privileged, confidential, or just very personal in nature from your clients. So understanding technology, the way it works, and the way the marriage between that and legal come together is crucial to your practice in any regard.
Right. And it's funny because there are certain instances, especially in my own practice, where I'll have conversations with clerks and they'll email me documents, and every clerk and every court and every county in the city or in New York has their own specific set of rules. For example, one clerk from Staten Island will tell me, I can't email you this type of information, and another clerk will email me the whole entire case. So it's hard for me not knowing the actual parameters of what's right and what's wrong. I'm just going by what these clerks are saying. Oh, well, we can't discuss this over email, but we could discuss it over the phone. So a lot of those little intricacies are it's difficult for small practice attorneys to deal with those types of situations.
It's so true. I mean, I'm speaking to a lawyer here, so you get it more than just as well as anyone in your position that this is not black and white. And again, this is why I love what I do, because I come from a place where I've had extensive experience being in courtrooms, dealing with court personnel or whoever it might be, and understand that one court it could differ tremendously from another unless it's specified in those rules. You don't know what you're going to handle. You don't know what you're going to get. Mm-hmm. So to be able to conform and work with different jurisdictions is tremendous for my industry. Mm-hmm. We're headquartered in New Jersey. However, a good part of my work is done in the boroughs, and I mean it's an amazing difference between one courtroom to the next. The district courts from the Supreme Court. It's unbelievable. Yeah. So to conform and be able to adapt to those folks, the courtroom personnel. Is tremendous, and that's one of the values added, I like to believe, that litigation offers our clients, the deference to the court.
That's great. Question number 4 here. You and I are both, probably from the same era. When I was in high school, there wasn't even computers. I think my senior year of high school, the first computer came into my school, and we used to have those little things called hard drives that are now the kids nowadays probably just see as the save button on their computer. So that's about 20 years ago for me, and obviously things have just boomed since then. So where do you see the future of your company specifically within the next 5 to 10 years, and the field in general of litigation?
Yeah, I mean, that's a great question, and I'd be lying to you if I could tell you with confidence as to what's going to happen. I would need a crystal ball, and maybe that wouldn't work. Mm-hmm. I mean, to your point, I recall having that one computer. It was in the library. We used Netscape Navigator. Everything was hardwired. Everything is locally stowed when it comes to data. I mean, I could have never imagined that we would be where we are right now. The ability to communicate by way of obviously phones, the text messaging, the tablets. I have cases, Anthony, where we have to collect communications that start on a text message, then go to a Facebook direct messenger, then are in an email. They're finishing the conversation in different applications. Right, yeah. Now, how do you practice when you have that? Right. First, it starts with getting in early, of course, and understanding, what's going on here. As the attorney representing the end client, having a very thorough interview process. That's where a firm like mine would come in to assist the attorneys, not to tell them what to do, but say, hey, you need to consider these parameters as to, how are folks in this litigation communicating? Because you'll be missing out potentially something tremendous if you avoid altogether some form of social media, maybe. So we are certainly quickly adapting and moving to the whole web-based, that being anything accessible by way of the world, the internet, and understanding that everything is going to a big webbed, cloud-based solution,
right?
And that's just the way it is. So it's going to be a lot harder, a lot more difficult as it is now to access that data without certain credentials. When you're in that proverbial cloud, bits could be residing in literally different countries. So to get everything together is not an easy task. But from a practice perspective, putting your adversary on notice, identifying where you believe data it does reside, or where communications were taking place, and having them or hoping that they comply with such demands or requests, or even seeking judicial intervention for some type of an order, so that the other side does not spoliate or destroy any potential evidence, either intentionally or inadvertently.
Right. I think this is a good segue for our last question, which is 3 tips for any attorney, specifically concerning electronically stored information. And I say it's a good segue because, and without getting into details of a specific case, is there a situation where, and this would work especially for solo practitioners and even practitioners in big law firms, where you're like, wow, you really shouldn't be sending this information on a text, or you shouldn't be sending this on an email, or use only this cloud-based software, or try to, in your best practices for your own clients and your own firm. What do you tell your clients? This is great that you do this. This is not good that you do this. So people know from the outset of what's the best practices in their day-to-day running of their firms.
Yeah, well, most cases I get in contact, or the client, the attorney's firm contacts me, and the case has started in most cases. Mm-hmm. So first thing we want to do is act early and identify where this data resides that deals with this case. Who are the custodians of potential data? Is your client using social media? Did they use? Are they currently using? Mm-hmm. I had a case a few months ago, a workers' comp matter, wherein a client came to me, the attorney, and said, and they were defending the matter, and said, hey, we've got a case, and I'm looking on Facebook right now, and this individual, the plaintiff, is claiming they can't walk, but I see them doing wheelies on their dirt bike. It's like, you got to wonder where their attorney is. I think this goes back to that competence point. Mm-hmm. I don't even know. This is beyond competence. Right, this is just common sense. Like, you're an attorney, represent even the plaintiff. Like, mm-hmm. What are you thinking right now? Is what I immediately think. So, in my position, there's certain things that are out there, particularly on social media, that we can't destroy. Right. We just need to stop in its tracks, mm-hmm. and make sure that we act, smart, or in accordance with the law and in the best interest of that person's case going forward. So, from my perspective, starting early, it's never too early to start. As soon as litigation is, as they would say, anticipated or it ensues, start figuring out what's out there, where the data resides, what devices were used. Like I said before, now with the smartphones and the tablets and other web-based applications, identify everything. Confer and consult with your client as it pertains to how they were using it, what email addresses are out there, and determine what's necessary to produce and what's not necessary.
Mm-hmm. And I think one tip that I kind of wanted to ask you about, and I know that we have discussed this in the past, is utilizing something like a mock jury. Now, do you suggest that to your clients? Is that part of a package that you offer them in terms of your support, or how does it come about? Because mock jury always seems like the number one thing that a trial attorney should get involved with. So can you speak a little bit more on that tip?
Sure. As I mentioned before, when it comes to my services, there's no menu here. Certainly, I offer certain things. They're depicted on my website. It has to be that way. When it comes to something like a mock jury, or any service, we're going to look at a proportional relationship between everything. Earlier, I spoke to exposure. What's the budget of the case? The volume of data. What phase are we at? Is trial starting in 2 days, or do we have 2 months? All that needs to come into play. That's the value litigation offers its clients. We really understand how a case works, how litigation works. And once we understand that, if the stars line up, if you will, with all those elements, sure, a mock jury just makes sense.
Right.
My wife is a practicing attorney here in New Jersey, and I can't tell you how many times she catches me in the kitchen, probably in the refrigerator, and she says, "Hey, what do you think about this?" or "What do you think about that?" I mean, this is all it is. It's water cooler talk. And our mock jury solutions, again, there's no black and white to them. I've had 6 to 8 hour mock juries wherein my client, the attorney, comes in by themselves, no demonstratives. I've got a panel of 8, 16, whatever it might be, mock jurors, and he or she just wants to throw different issues, different points of view, different things out there and just get the vibe. And then I've had these full-fledged trials, mock trials, where my attorney firms or the firms that I work for will come in, they'll bring an associate or a partner. We won't disclose who is really on what side, of course.
Right.
I'll have 32 to 100 mock jurors. We'll split them up. We'll have demonstratives. I'll do the trial technology, or my office will do the trial technology for the mock jury. We'll have the witnesses come in live. We'll test different theories. Have the jurors deliberate, execute a questionnaire and a verdict sheet, and come to the table with an opinion. I've never done a mock jury where the end client wasn't impressed in the sense that they did not anticipate certain things going, one way or another.
Yeah.
I haven't had a mock jury where my end client didn't choose to work with us, my firm, on additional demonstratives or cancel demonstratives because of the mock jury. And that's really what it's about.
Right.
Sure, we want to earn money and make as much stuff as possible, but sometimes it's readily apparent when you have these independent folks telling you, that display just did nothing for us, or muddied the waters, or whatever. It's an unbelievable tool, in my opinion. I'm shocked that trial attorneys don't use it more often, but I'm very confident that they are doing this, whether it's in their office or at their home, in one way or another, and just not calling it a mock jury.
Right. Of course.
But that's just what attorneys do, litigators do. They're going to throw ideas back and forth. But it's a fantastic service, and
yeah,
I can't.
That's great. So that's it with our questions. Just want to give you a couple of minutes to talk about anything else you wanted to add here before we wrap up. So go ahead. The floor is all yours.
Oh, sure. I appreciate it. As far as technology goes, I would just encourage my clients or anyone out there listening to embrace the technology. It's certainly not going to be right for every case, but at least understand that it is there. It's meant to help. It should streamline and expedite certain parts of your litigation. And then again, in certain cases, it could be a little bit of a roadblock. So understanding what's there and when it fits is the most important thing. There's also misunderstood stereotypes as it pertains to the cost. Nowadays, technology is rather inexpensive. Anthony, years ago, not many years ago, maybe 3 to 5 years ago, a terabyte hard drive was several hundreds of dollars or whatever it might be. Now you can get it for well under $100. So media and the means of stowing data are so easily accessible and reasonable as far as cost goes. So I would encourage anyone to consider their technology and their options. I'd certainly encourage folks to engage a litigation support provider, a consultant, a vendor, whatever you want to call it, someone like Litigation or wherever you may choose to go. I think it's important because while you deal with the substance of your case and the legal, you should hear from someone that has the experience with whether it's the e-discovery collections or the data culling and review, or even the trial technology. Hear their perspective, their point of view, and what might merge or marry with your legal points or defenses to work best for your particular case. So.
Great. Practically speaking, a lot of my listeners and viewers are from all over the country. Can clients all over the country use litigation, or are you limited to New Jersey, or what's New Jersey, New York, or do you work in all 50 states? Just so the people that are listening or watching this get an idea of who you can take on as a client.
No, absolutely. We work. Look, data. It has no boundaries. Of course, we can work with firms all over the country. Frankly, all over the world. We don't have many, but we have a few firms outside of the country. 2 days ago, we did a video conference deposition with a firm out in another country. I was here locally in New Jersey, as a matter of fact. We video conferenced in. We had an interpreter, a court reporter, and we made that happen, and we captured that video deposition. I've done trials across the country. When it comes to data, it's very easy to manage, process that data, and make it available. Again, most things are web-based now, so wherever you have an internet connection, you should be able to access it. But thanks for mentioning that. Absolutely, my support firm has no boundaries as it pertains to where we can service.
That's great. In closing, I just want to say, when I look for a company as an attorney who I want to work with, it's always going to be the company that's comprehensive, that cares about their clients, and really just knows how to treat their clients. And from our conversations and me just knowing you, I know that you do work like that. So I appreciate that, and I urge anyone that's in need of any litigation services to contact you. And if you want to share any ways that they can contact you, please go ahead. Let them know how they can get in touch with you.
Yep, the best way is to visit us on the web. We have a website established. That's Litigation, LITEGATION. We've replaced the I with an E for e-discovery, ESI, what have you. So LITEGATION.com. And therein you can find information about our services, our experiences, the recent awards that we have won through the Law Journal, as well as our contact information. Thank you, Anthony.
All right. Thanks a lot, James. So, again, I appreciate you coming on. I appreciate you being our first video guest here for the podcast. Once again, this was Sessions with an Adoption Attorney, and we had on James Cortopassi from Litigation. And you could reach me on the web at www.nycadoptionlawyer.com, on Twitter at nycadoptionlaw, and even on Instagram at nycadoptionlawyer. Thanks a lot, James. Great talking to you, and I'll talk to you soon.
Thanks so much, Anthony.
All right. Bye-bye.
Bye-bye.